Good afternoon, classmates and instructors. My name is Aisha Williams, and I'm weighing in as a juror for case number 3. The case concerns plaintiff Jennifer, and the defendant is AI Hospital. I am actually finding for AI Hospital. My reason for finding for AI Hospital is the simple fact that according to the order that was received, this was a court order. It was not with a subpoena or anything, but be it the fact, all companies have to be in compliance with court orders, subpoenas, wherever they receive from a judge, a state, a governmental organization or something like that. If it's an order, then all companies have to be in compliance with orders. Court orders, that's everything. Now, my thing is, under the HIPAA guideline, yes, a patient's privacy was violated in a way because Miss Jennifer did not know that her information was being sent. Now, be it the fact that this is an open court case that is going on, my thing is, if Jennifer knew that this was a court case going on already, then she knew that sooner or later the proceedings of this court case would be requested. So, since her information was requested through this court case, I actually see that she had prior knowledge and understanding that her information would be requested already. Now, whether the doctor or the hospital that she was dealing with let her know, is that in the right or the wrong? No, they were not in the wrong because under HIPAA guidelines, even though you have a right to privacy 24/7, 7 days a week, that is granted. That is given to you by the law. That any information you disclose to your doctor or the hospital that you deal with is covered by the HIPAA guidelines. And yes, um, it is your right to have that kept private and kept to where still nobody else can access this information but those that need this information. My thing is the simple fact, and the only reason why I am finding for a hospital is for the simple fact that under the HIPAA guidelines and under some articles that I read, one article that really caught my attention was how to respond to a a court order subpoena for patient medical record. And there's a couple of different guidelines and breakdowns in this article. And the more I read in the article, the more I realized that according to the article, it states disclosure pursuant to a court order. It states here in this article, HIPAA allows a covered entity or a disclosed PHI in the course of any judicial or administrative proceeding in response to an order of a court or an administrative tribunal, provided that the covered entity disclose only the protected health information expressed authorized by such order. It also says see CFR 164.512 E1I. In other words, if your practice receives a court order signed by a judge that that directs an individual physician or the practice itself to release a patient's information, you may do so without the patient's authorization. However, you may disclose only the PHI that is expressed and authorized in the court order. Therefore, as long as the hospital, the doctor, or the practice wherein only gives the information that the order is asking for, they were not in the wrong. So therefore, my findings for AI Hospital. I am sorry that Miss Jennifer feels like she was violated and wasn't well informed, but at the end of the day, no matter how you look at it, the guidelines are just the guidelines, and it's based and stated accordingly that this practice did not have to let Miss Jennifer know that her information was being sent out because they stayed within the guidelines and they only sent out the information that was requested according to the order. And for this hospital to be within their practice rights and to be following the HIPAA Act accordingly. They were only able to release just the specific information according to the order. And since they only released that specific information, they did not violate Miss Jennifer's HIPAA rights to have her information kept private. Her privacy was not violated by any level, and they were in their rights to send out the information that needed to be sent out, because had they not sent out this information, their practice could have been held in contempt of court. So to prevent their practice from being held in contempt of court, they followed the order according to the order itself. Therefore, my finding, once again, is for AI Hospital. I am sorry that you feel like you were violated, Miss Jennifer, but you were not violated. Not according to the rights in the HIPAA Act, and that the fact that the hospital follows the rules accordingly. Thank you.